Hey, everybody, this is Greg Burt, Vice President of the California Family Council, and we have a special guest with us today, Nicole Pearson. She's an attorney, the founder of Facts, Law, Truth, and Justice, coming to talk about a very concerning bill that threatens your parental rights. It's AB 495. You probably heard a little bit about it, but we're going to get into the details. But before we get started and ask questions of Nicole, let's watch what she said before a Senate committee about this bill just several weeks ago.
Immigrants and an attorney who spent her career helping immigrants and fighting human trafficking. I am also desperate to help children affected by ICE raids, but AB 495 is not it. We all know this because in 2021, the federal government faced a swell of unaccompanied minors at the border and was desperate to place them quickly. What did they do? They reduced vetting procedures, and as a result, the Department of Homeland Security has lost track of over now 600,000 unaccompanied minors. Despite this, California wants to do something similar, but even worse. With just one sheet of paper from the internet, California wants to let someone that is not related to your child remove her from school, enroll her in any other school in the state, authorize any medical treatment of her, including mental health services and drugs, without the parent's notice and knowledge or consent. This is not fear-mongering. I'm not being hyperbolic. It's stated right here in the caretaker's affidavit that I printed for you, which I pulled directly from the bill. Line 6 allows this transfer of parental rights without even having to speak to the parent. The author claims AB 495 is about giving immigrant families the agency to choose the safety plan that works, that preserves family unity. Where is the parental designation? Their signature at the bottom here is not required. She's co-opting a term non-relative family member from the foster care and dependency probate systems, but without any of the procedural guardrails. No background checks, no interviews, no home visits, no fingerprinting, parental involvement, or civil, criminal, or professional liability if the child is harmed. Just 100% blanket protection for any adult seeking to abuse any vulnerable child, because this does not limit it to immigrant children. This applies to every single child in the state. Our children deserve to be protected through proper legal channels that currently exist, that have safeguards, and not just shortcuts that enable exploitation. We appreciate the author's intentions, but these unintended consequences are terrifying and they're unavoidable. We have systems and agencies in place that track and ensure children are safe and returned to their parents while respecting parental rights. We can and must support immigrant families with solutions that don't gamble children's lives. Please vote no on AB 495. I remain committed and offer my services to the Assemblywoman, free of charge, to help find solutions that work and actually achieve her goals. Thank you.
Thank you very much.
There she is. So glad that you're with us. That was fabulous testimony. Nicole, let me start by bio, just to give our listeners some understanding of who you are. Your bio here lists that you're a mother, a constitutionally attorney, the founder of Facts, Law, Truth, and Justice, a constitutional law firm and human and civil rights advocacy group that's focused on protecting children, enforcing our rights, and defending our freedom. It says here that you have sued presidents. I don't know if that means presidents of companies or countries. We'll find out. Governors, counties, public and private university systems, school boards, politicians, and individual bad actors, and has been on the front lines to restore the country's founding principles of limited government, checks and balances, personal autonomy, all necessary for a free and healthy society. That sounds great. Appreciate you being here.
Say that 10 times fast. Right after the name of my organization.
That's right. Facts, Law, Truth, and Justice. So tell us a little bit how you founded this law firm and the kind of work you've been doing, and especially on the issue of parental rights.
Well, in 2018, I had my second child and was trying to wind down my law firm. At that time, I was a solo practitioner. doing plaintiff's work, representing employees, and doing a lot of employment litigation. And as I was trying to wind down, then COVID hit. And so initially I was terrified. I have two children. One has a respiratory lung condition and my other child has a heart condition. And so I was very scared of COVID, and I yelled at people for not staying home to flatten the curve, and washed my groceries and made people get naked before coming into my house, and did all of those things that they gaslit us and terrified us into doing. But within a couple of weeks, I realized that things were not right. And I realized that the government's actions were very inconsistent. They were contradictory to the propaganda that they were spewing. And at the same time, I was receiving a lot of text messages from my friends that had children, started to have children, sooner than I did, and had children in school. And then I started to hear about forced vaccinations and vaccination clinics on campuses, school campuses, and that there was a leaked video from a government official saying we're going to vaccinate these kids on campus. And people were saying, well, what if the parents aren't on board yet? And he said, well, we're just going to have to force them, make them get on board. And if it hadn't been for this perfect storm of, series of events and unfortunate events, then I don't know what would be happening now. But that's what happened, made me realize that things are not right. And so also I live in Orange County, which was one of the counties they wanted to launch the vaccine, the digital vaccine passport here, San Diego, Ventura County. That's why I think you see a lot of patriot freedom fighting activity in these counties, because they wanted to launch the pilot programs in these conservative counties, thinking if we can get this going in conservative counties while people are asleep, we can obviously get them going and connect them to San Francisco and Los Angeles and all the more liberal counties. So when I was thinking, oh, the vaccines are out and I can't wait to get one for myself and my kids, and I called and was like, when do we get them? And they said, oh, we can't give them to you till our digital platform is up. That was the end for me. I was like, what? So that's when I realized. I started paying attention. I started looking at the laws that they were passing, emergency resolutions and everything they were doing under the guise of emergency, rush, expedited, and confidential proceedings, and realized there was, lifted the veil for me, the curtain, and I took a peek behind, and that's when I realized the government is not here to save you and is not on our side, but the law is. And so I decided to start using that to our advantage and fight back.
Awesome. And so you formed this organization. I know I've seen you up here, multiple times speaking up. You do a lot of social media, do a lot of interviews. So really appreciate your work, and especially the work that's been, we're trying to raise people's awareness about this bill that we had not paid much attention to till the beginning of July. This is a bill. It's AB 4495, and it specifically is supposed to help with situations where parents who are undocumented get taken by federal immigration authorities and they leave their children behind, and what happens to their children, right? And right. The bill sounds like it's about making sure that parents have a good place to put their kids, and the kids aren't just taken away and given to anybody. But when you start looking at the bill itself, that's exactly what it actually does. And so I know a lot of you've been speaking about this. You wrote a great piece that you published today on your Substack, which is actually a letter that you sent to the legislature. And you're really, what this letter is you're going over the history of something called the Caregiver Authorization Affidavit. That is the most concerning thing about this bill. It takes a existing form that's been around for decades, it updates it, and it actually is making us aware of this form already has all kinds of problems to it, and it just makes it worse. So to help people understand why we were saying some kind of crazy things about this bill, because you're going to hear like it's the child kidnapping bill, or it's the trafficker's dream. And it's like, okay, this is what they call hyperbole or exaggeration to get people all riled up to oppose something. But I want you to understand that we are not exaggerating. We are trying to specifically let you know the implications of the language of the bill. And so, to convince you, we've got Nicole here to walk you through the history and explain what this affidavit actually does. So, Nicole, if you could do that for us, that would be great. Just at the beginning, like, how did this affidavit come about, and what's been the progression over the last 20, 30 years?
Well, I actually know and have been working with the author of the original bill who created that caretaker's affidavit. And he is an attorney. He works in foster care. He has a firm that focuses on foster care children and placing these children and specifically trying to remove them from the foster care system to place them with loving families, Christian families actually as well. And also supporting the biological parent. But that's a separate story. But I have spoken to him, and I understand, given my work as well, I understand where the intent of the original 1994 bill came from that created the affidavit, because there are instances where a family, a couple passes away or something happens, they're incapacitated or incarcerated, and they didn't spend the couple $1,000s to put together an estate plan of get a will or get a trust in place or even a power of attorney in the event that something happens to them, to plan for what happens with their child. And a lot of people have godparents, and a lot of people's godparents or the godparents of their children aren't family members. Sometimes they want to extend that supportive community that your child will have if something does happen to you, so they invoke the assistance and the support of their best friends, for example. So we have godparents who have been with the child since very young age, baptism or whatever the commitment ceremony or whatever the case may be. They are the godparents, but they're not related. And so something does happen to the parents who don't have an estate plan, don't have a plan in place to provide for the child when something does happen to them. And so the caretaker's affidavit came from that. And so it allows a parent, a caretaker to fill out this form. You have to be over the age of 18. They claim in the form, in the original form, that I'm over the 18 years of age, the child lives with me, and you provide the child's name, date of birth, the caretaker's address, and a name, sign under penalty of perjury. And with that piece of paper, you can take it to the school to authorize enrollment and educational services, and then any school-related medical care. And then if you are a relative, the way that the law currently stands, if you are a relative of the child, which is very broadly defined currently, then you can also, and you have to attest under penalty of perjury, you can also take that affidavit to the school, authorize educational services, medical care, and then any medical care throughout the rest of the state. And I don't know if you want to keep going, but that's what the affidavit says, and it's for that purpose. That's where that was a genesis of the bill, according
Right.
to my understanding and my conversations with people who created the affidavit in the 90s. And I will tell you that in my experience, my law practice, I have seen affidavits. I have never, ever one time seen an affidavit without a parent's signature. I would say about upwards of 96% have had a notarized parent signature. And most of them, I would say upwards of 80%, also had the caretaker's signature on the piece of paper. So it exists. And in good scenarios, it is used by a parent who wants a semi-formal document to be in place. It's in your drawer. It's in your intended caretaker's drawer. And then if something happens, they pull it out and you have these signatures on it. And it is actually a tool that parents can use to plan. However, there is a nefarious side to these affidavits because they don't require background checks, fingerprinting, identification, interviews, hearings. They can be used outside of the judicial systems and processes. And so it is ripe for abuse already currently as it exists.
Right. So currently, I'm looking at I printed out the original form. I got this off of out of the Family Code. You go to the California's Family Code laws, and you can find this affidavit.
Section 2.
Yeah, and now now on here it doesn't say anything about whether a parent needs to sign it or not. Now,
Right.
from your
It is
understanding, they
silent.
don't need to. Is that right?
They do currently. There's no requirement either way because we want to keep it open for the emergency good faith scenario that I went over with the godparents who are friends but not relatives, right? But in practice, and with all of the attorneys that I've ever spoken with, because I've done a lot of research once the bill came out, I know my personal experience, but obviously I don't know other attorneys in the foster care dependency systems. All
Right.
of us, 100% across the board have said, I have never seen one without a parent signature. Most of the time it's notarized, and 80% plus of the time that caregiver's signature is also there, and it's typically notarized as well.
Right.
So it's silent. But what Celeste does is make an affirmative declaration, basically like a bat signal to traffickers and kidnappers and abusers. A parent signature is not required. A parent signature is not required. So she's now taken this shield and turned it into a sword to really, forcibly exclude parents from this planning process.
Right. So I might have the updated version, which is, if you can find it, this new language we both have it. It's in the bill language itself. And 3 different times it says on here, and I'll read. Here's the first time. It says, warning to local educational agencies and healthcare service providers. A parent signature or a seal or signature from the court is not required. And then it says it again when it says, has a little note here to school officials, says the same thing. Another note here for healthcare providers, it says the same thing. So they want this not to be used. They want it to be used without parental knowledge or consent. Now that is where the problems occur. Now, but one of the interesting things in your analysis that you put out today is that the bill has changed over the years, and during a 5-year period over the last couple of decades, they used to require a signature. What was that?
So, and it was enacted in 1994, and it allowed the authorized caregivers, the 2 different types of limited, more narrowly defined caregivers, to authorize what we discussed just a couple of minutes ago. Then it was amended in 1999 to add mental health services. So people need to know that these caregivers can currently also consent to mental health services. And then, as you mentioned, or that was in 97, 96 or 97, 99, there was a Republican legislator who saw that the affidavits were being abused and added the 2 requirements, again, to protect parental rights, because that's what we need to be doing. These are to be used in case of an emergency until a permanent plan can be put in place, one that is legal and one that also protects or respects the due process, fundamental constitutionally protected due process rights of parents. And so he required, number one, a parent signature, not notarized, but a parent signature, number one. And number two, he also made it so that there was an automatic expiration date, so that they automatically expired at 1 year and would have to be renewed every year from the date of the signature, of the caretaker's signature. Again, we're doing those kinds of backstops to ensure that we are in constant communications with the parents to the extent that they are around and available. And then if they're not, certainly the judicial process has already run its course and the child should be placed by that time. Otherwise, then I guess out of necessity, it would be renewed. But again, these are the types of guardrails that we need in place to be ensuring that these children, in California, the number one priority in in dependency proceedings and child custody proceedings is maintaining a relationship with the biological parents and reunification with the biological parents. I have never personally in my work since 2005 in law have never seen a parent's legal rights to visit or have some sort of relationship with the child terminated. And I have seen horrible cases of abuse, substance abuse, whether it's substance abuse or child abuse. They're always hoping that the parent rehabilitates, and they always want them. It would be some sort of monitored or supervised, relationship, but there's always this emphasis on maintaining a relationship with both biological parents.
Right,
and
right.
So, and these are the types of guardrails that we see that ensure that. Then
so
very
those
quickly,
guardrails were put in place in 1999,
Yes.
And then what happened in 2004?
They were removed. Both of them were removed, of course, because
So,
now we
so
had
the so the
the
signature
signature
of parent was
and,
no longer required.
and the 1 year time limit was no longer required. The 1 year limit was removed so that the affidavit can exist into perpetuity unless and until the medical provider or the school receives notice that the child is no longer living with the caretaker. But again, when you are dealing with the nefarious scenarios, when you have someone has kidnapped the child, is possibly kidnapped and abusing the child, they're not going to let the school or the medical providers know. They're going to keep things under wraps for as long as possible. And so it's just mind blowing to me, and people need to know. And this is, I talk a lot, I write a lot. I do this because I need people to understand, like you said, there are ways to have an affidavit in circulation, in effect, that protects children and also parents. Number one. Number two, you need to understand that this is the current law and this is what exists currently today that has placed your rights as a parent and your children at risk. This exists today. And now we have Assembly Bill 495, which is going to, I can't even articulate, AB 495 will literally make it so that anyone can use this affidavit, remove your child from school, and authorize any type of medical care, including surgeries, depending on the age of the child. We can get into the requirements of that. Mental health services, drugs, surgeries, therapies for your child. And when you're dealing with a child who's been kidnapped, you want to have them drugged. You want to have them confused, alienated, brainwashed. And this is the affidavit is a license to allow their kidnappers and abusers to do exactly that.
Well, here's the updated form. Let's go through it and just explain how it's supposed to work, because it's interesting. So why don't you explain, like 1 through 4, like completing the first 4 questions on here gives you certain rights. No, so what's with that?
So let's be clear. If anybody after they watch this is going to share this interview with everybody that they know in the country, and I will explain why in a second. And number two, they're going to just Google caretakers authorization affidavit, and it will be the first link that should pop up is from the California court's website. And for free, anybody can currently, and this will be the same case with the updated version of AB 495 passes, is they will be able to download. Any single person that has access to the internet and a printer or 10 cents at Kinko's will be able to print the caretaker's authorization affidavit for free, essentially. So anybody can do that. And then like you mentioned, there are 8 fields that you can enter. So if are we doing currently or if AB 495 passes?
If 495 passes.
Okay, so if 495 passes, then someone who provides the answers to the first 4 fields, which is the name of the minor, very easy if you're a predator to get name of the minor's birthday, also very easy. Then the alleged caretaker's name and the alleged caretaker's address. And I say alleged because there's no identification requirement for these first 4 pieces of information that will allow the caretaker to take the affidavit to his school and to authorize unenrollment, enrollment, and school-related medical care. They sign under penalty of perjury, but I'll just speak from my experience. Most kidnappers and human traffickers don't really care about penalty of perjury, especially when they've already fled the state or the country with your child. It doesn't really matter. It's not very intimidating. I don't care what kind of font you put it in. So with those 4 pieces of information, 2 of which do not even have to be verified, again, the caretaker's name or address, they can remove your child from school, enroll your child in any school of their choosing, and authorize all school-related medical care. If you look that up, that includes immunizations, that includes, your physicals and mental health services, therapies, which you guys all know the types of therapies and counseling they're providing at our children currently in California public schools.
Right.
Then,
wait, before you go on, now I did some asking to some school board members, like ask them what do they do when parents can't be reached and the somebody shows up and do they have access to your kids? Who will the school give the kids to? And I was told typically schools, one of the requirements to enroll your kid in class, you have to give all the possible adults that you want to, it's called an emergency caregiver
Contact.
list,
No,
right?
emergency contact form. Yeah.
Right. And so and the parent lists out who gets to take the child, right? And she said, that's how we decide who gets the child if the parent's not around. And I said, well, what happens when they come up with this caregiver authorization affidavit? And she goes, well, I don't know. I'm going to find out. And so here's what I got sent back. It is from an organization called the California School Board Association. This is the School Board Association that gives advice to school boards, helps them with policies, and this is a legal guidance on immigration issues. And so she sent me this, and I went to page 6. And here's what page 6 says about these caregiver affidavits. And so if you want to know what schools are doing, how they treat these affidavits, let me show you the advice. It says families should be notified. This is the advice that it's being given to school districts by this legal memo. Families should be notified that in the event that a student's parent or guardian is detained or deported by federal immigration authorities, administration release the student to the person designated in the student's emergency contact information. That's what we said. That is who gets the kid. But then it says, or any individual who presents a caregiver's authorization affidavit on behalf of the student. So here's the legal advice to school districts. The person who fills out the first 4 questions, which doesn't require any ID, it just requires you to put down a home address, a name, a minor's birthday, and a minor's name. It doesn't require you to be a relative or even know them. And the school is supposed to turn the child over to that person, even if they're not listed by the parent as an emergency contact. Did I get that right?
Yeah. And really, honestly, like hearing you say it, and I've read that, you shared that with me, it's like very terrifying. It's really upsetting. And that is exactly what will happen. I mean, that is the official legal advice from the California School Boards Association that every single school board is being given right now. And it's the same thing that happened with COVID. They gave bad information, they violated people's rights, they violated children's rights, and as a result, thousands of children were injured. Some of them died, and some of them were removed from their homes. Parents, I mean, it's the same playbook. They do it every time. They're lying to you. They do it under the guise of I call it a Trojan horse. Every year there's a Trojan horse, this untouchable, very salacious, and emotionally charged theme, whether it's systemic racism, Black Lives Matter, COVID, vaccines, transgenderism, and now immigration. And they pass these horrible guidance. They issue this horrible guidance so that people, are eating it up, do it without thinking, and don't say anything because they can't. Because if you object or you question it, then you become a transphobic, bigoted, racist, or what it's COVID deniers, grandma killer. So, anyways, it makes me really upset, and that's exactly what will happen. And it's very scary. The other thing I want to point out is that on the front is the affidavit, and on the back are some notices. And the second notice, so like Greg mentioned, there's notices to caregivers and notices to school officials and then to healthcare providers. But at the very top are notices for all of those individuals. And it says a person who relies on this affidavit has no obligation to make any further inquiry or investigation. So Celeste Rodriguez and Rick Zabur and the other proponents of this bill are saying, don't need ID, don't need to confirm who this is, don't ask any questions, parent signature is not required. It is a recipe it is a kidnapper's dream come true.
Right. So we just mentioned so far items 1 through 4, right?
Okay.
So
right.
We haven't got into the in that you can, with the first 4 items signed, that doesn't give you the authority to make decisions on all medical decisions for the child. if you want that kind of authority, you need to fill out 5, 6, 7, and 8. So explain that. What is 5, 6, 7, and 8, and what new authority does filling that out give you?
So remember, 5, 6, 7, 8. So currently, only a relative, which is currently broadly defined, can actually even fill out sections 5, 6, 7, and 8. But
Right.
what Celeste Rodriguez and Rick Zabur et al. Want to do is to, number one, expand the definition of relative to include people up to the 5th degree of kinship, which is a very large number. Greg and I are debating with
Right.
our chat.
That's your second, down to your second cousins.
Second cousin step and X. So if it's your great grandpa's ex-wife stepson, technically he would fall under the term of relative. I mean, if you really play it out to its logical conclusion, and Greg, because he and I are having a math debate and neither one of us seem to be math geniuses, I think the reason that I got in the thousands was because I included step and X, because that's what multiplies this out and out. So let's just say several hundred individuals fall within the term of Celeste Rodriguez's new relative. But in addition to these new hundreds of relatives, she also wants to include non-relative extended family members, which is an oxymoron. If you're not a relative, you're not a family member, but they try and trick you. A non-relative extended family member is not a family member, and they define it on the back. And in Family Code section 6550 and 6552 to include someone that has a mentoring or familial type of relationship with your child, number one. And then she lists specific examples, including but not limited to, of course not, including but not limited to, and pay attention, teachers, medical professionals, mentors, like we just mentioned, neighbors, family, friends. That is very alarming. Again, if you've been paying attention to what's been happening in California schools, then you know that there are teachers and there are medical providers, albeit there are tons of amazing ones, but there are some very dangerous ones who want and have access to your children and will certainly claim they have a mentoring type or even a familial type, like a rainbow chosen family, perhaps, type of relationship with your child, and that they fall under Celeste's new non-relative extended family member term, and then fill this out and submit it to the school to authorize enrollment, unenrollment, school-related medical services, and then any type of medical service, even beyond the school setting. It's horrifying. I don't even know. This is a very dangerous bill, especially right now with what is going on in California schools, which Sophia and Greg are intimately aware of, along with myself.
Right. And then under that's number 5. Oh, no, number 5 talks about being a relative or a non-relative, right?
Mm-hmm.
Then it says you have to check a box. There's 2 different options. One is you've told the parents and you've advised them that you are taking legal custody, other persons are taking legal custody, and that you're going to make some medical decisions on their behalf. So more or less the parents are being notified. But then the other option is
yes, sorry. Yeah.
Then the other option is I'm not able to contact the parents or the other persons having legal custody of the minor. Now, who verifies that that's true?
Nobody, because they're not allowed to. They're not allowed to, and they don't have
so
to.
The parents could be, at home.
Yes.
And somebody else comes to the school and says, "Hey, we can't find the parents." And the school has no obligation to verify that's true?
Correct. And remember, and well, not remember, before I go to the next point, they also say at the very bottom, to any healthcare provider that provides services under one, using or relying upon one of these affidavits, is not subject to civil, criminal, or professional liability if they make a mistake, even if the child is harmed. And I know in the preamble of the bill, they say, we're not trying to usurp parental rights. The parents' decisions will control. And if anybody, harms a child using this new affidavit, they can be subjected to other types of liability. Well, I'm here to tell you there's no other type of liability other than civil liability, criminal liability, or professional liability, for example, with the medical board. So if they have, it's blanket immunity. So they're, again, like I said, She doesn't put any affirmative obligation. In fact, she tells the people relying on these affidavits, you don't have any obligation. Don't worry, no signature is required. And even if you make a mistake, you're not going to be in trouble anyways. So no one is going to be doing anything. And again, we need to go back full circle, the Trojan horse. If you ask, you're a racist. If you ask, you're a bigot. So the school policies are going to be don't ask, don't tell. It's going to be that. And the last thing actually I do want to say is if you read the bill, she also says that CPS cannot be contacted. It's in the bill, section 6550B. She doesn't want CPS to be notified. Why? Because they are trying to protect, again, the theme of the bill is protecting undocumented immigrants. And so CPS is actually not allowed to be informed or advised, again, all under the guise of protecting undocumented immigrants and their status and their privacy, and then not having to turn them over to or cooperate with federal agents. So again, under the misinformed, ill-advised intent of protecting immigrant families, she has created a piece of paper that will allow these children to be taken and abused and medicalized and sterilized and even worse, and these parents will have no idea whatsoever.
Right. Wow. Okay. So, and then number 7, you have to give out your birth date, which doesn't seem like a big deal. But then the last thing, it says my driver's license or identification card or government issued consular card number. So
Number.
What is number?
The number. So it's the number. And by the way, on the back, it says if you don't have that, don't worry about it. If you don't have any of these items that Greg just listed, you can also use your social security number or your Medi-Cal number. So all the piece of paper needs is for you to come up with 9 random numbers and a letter, because I think my driver's license has a letter and then just a couple numbers. Put it there. Again, what does it matter if she could ask for your passport, but if no one is checking, it doesn't matter. But by the way, she's not. She's saying you can write down any 9 numbers here and then we'll consider the form complete. We don't have to ask any questions. In fact, we won't ask any questions. And even if we should have asked questions, we can't be sued or put in jail for a mistake anyways. So it's just, I don't even, anyways, there's nothing really to say about that.
Now, I went to the author's office yesterday at the Capitol and talked to the ledge director. And she said, well, this is obviously not our intent. We don't want to have a bill that makes kids vulnerable to kidnapping and trafficking. I understand it's not your intent, but you've got people scared to death because that's what the bill actually allows to happen. And she goes, well, you can't just take one of these and go to a school and get a child. And then I said, well, and then I read her what the California School Board Association is saying, and she was not aware of that. And so she said she had to go back and talk with the sponsors of the bill. Now, so the author of this bill did not write this bill. This bill was written by an immigration child advocacy group, which I had never heard of before. And so and that's probably the problem. This is a brand new legislator wanting to do something in an issue that's obviously our community is concerned about, and she's handed a bill. This will help. And I doubt she knows the 30-year history of the affidavit, doesn't know exactly how it was supposed to be used, and trusts the sponsor and what the sponsor said the bill would do. And this is what I see happening at the Capitol all the time. We point out something in the bill that's very concerning, and they come back, well, that's not the intent. Like the intent matters.
Right. Right.
But laws are words on paper, right? They are not the intent. If the intent is different than the words, then there's a problem, because the words are going to be used to enforce the law. And when you go to court and you try and use the words on the piece of paper, nobody knows what the legislator's intent is 5, 6 years, 10 years from now. That's not going to matter. It's the words, right?
It doesn't matter. I mean, even people who are listening and watching, it's like when your husband intended to be home on time but wasn't home on time, it doesn't really matter. I intended to pay the bill on time and fully, and then the banks don't really care about that. And by the way, it's important for people to start calling the legislators now, submitting their opposition papers now, demanding that they're Republicans. You made a really good point, Greg, the other day. We need Republicans to get loud and educate their colleagues on this bill, not just vote no on the bill. We appreciate that. Thank you. But we need you to be advocating for us, because, if this passes, which it won't, but if it does, the lawsuits take several years to win. And the same way we won in COVID, going back to my story, like, I would not be doing what I'm doing. And I know you would not be doing what you're doing if you did not know in your heart of hearts that you were on the right side of the issue. And in my case, as a lawyer, I know the law is on our side. And so I will win in 3 years. And then they'll probably appeal it. And then I'll have to, it's years and years and years. And in the meantime, tens of thousands, if not hundreds of thousands of children will be harmed. Just the same, and it's not hyperbolic because it happened already under the Biden administration. I know no one wants to talk about it, but when there was this surge of unaccompanied minors, like I mentioned in my testimony, they have now admitted it's not 325. They have lost track. They have lost 325. They do not know where they are. And then an additional
325,000.
Thousand they have completely lost. And then an additional 275 they cannot keep track of. They're like around, so it's actually 600,000 children that they cannot track, and have more than half of which they can't find at all. So we've already done this before. We've already done this to immigrants and undocumented immigrants and their children. Why are we doing it again? We should be doing Celeste, to her credit, Celeste Rodriguez, to the extent she does want to help her community, there does need to be a bill. There needs to be a bill like the 1999 bill that requires a parent's signature. We absolutely protect immigrant families, especially undocumented immigrants who are scared and who want to plan for possible ICE detention. It is a very real possibility right now. And she calls this the Family Preparedness Plan Act, and she talks about it in the hearing. We want to give, honor their dignity, give them tools and resources. Number one, go to California court's website. There are dozens of free downloadable forms in many languages to help parents plan outside of the court system. You don't need $1, maybe just a couple of dollars to print, but you don't need any money to plan. Have these documents with your signature, your husband, your partner's signature, and the caretakers. There's already resources available. There are already organizations in place to help undocumented immigrants. There is a court system. These children will never be left alone. I'll go into that more if you like, but if you want to help them plan, ensure that they are involved and make sure that they're getting the information so that they can plan, while protecting children and honoring their rights and ensuring reunification, which is, again, always the goal of the California legislature and court system.
Right. And I know you've worked with the problem of human trafficking here in California, and so have we with our organization. California is a hotbed for human trafficking involving minors. And so imagine how a trafficker can take advantage of such a bill to make a kid disappear, right? And the best way to protect them is to keep them connected to their parent. But imagine an undocumented person has come across the border, is working somewhere, and has kids, and all of a sudden they are taken. Those children are they are right then the most vulnerable to being stolen, taken by a human trafficker, and then starting to be used and sexually abused. Why? Because that parent doesn't have doesn't have other people they know here. They don't, and so the trafficker would know that, and all they got to do, they know where the kid is in school. Fill out one of these affidavits, and the school will have to turn the kid over to them.
I know no one wants, and I know no one wants to talk about this, but let's use that example. So I haven't gone there, but let's use that example. There are currently children that are being trafficked right now, like you were just mentioning, and they use them for sex and they get pregnant. Now, with this caretaker's affidavit, they can go take them to get multiple abortions, get them on birth control, get them drugged, right? We need Ritalin, or not Ritalin, the opposite. We need drugs for this kid. I'm the uncle and I couldn't contact, like you just said, I couldn't contact. I checked the box. I tried to contact. I couldn't contact the. Now we have this child drugged and then also taking care of any issues that arise as sexually transmitted disease. Now the traffickers can do that, because people tell me like a kidnapper is not going to use this. A trafficker is not going to use this. Absolutely, they will use this. This will help their business model. This will help them keep their product in circulation for as long as possible. And again, it's also just about being able to remove a child from school, because when you're in school and the child is in school, we have mandatory reporters, the teachers, the aides, the counselors, the coaches, everybody's a mandatory reporter. There technically should be somebody that is watching all of the kids, checking in with the kids. And when they notice something and they have reasonable cause to believe that the child is being simply neglected, they must contact law enforcement and child protective services. So allowing the affidavit to allow people to remove children from school, because that's what happens a lot when you see these human trafficking cases and these children who are being sex trafficked, especially, certainly if they're being abused, right? You want to get them out of the school because you don't want the marks to show up and the teacher to report you. But when children are being sex trafficked at night, they come to school, they're not performing, they're sleeping a lot because they're up all night. And it's like so upsetting to talk about. So you want to be able to remove them legally from school, and you will be if AB 495 passes. I don't think that Celeste, that's why I haven't gone full nuclear on her, because I don't know her. I don't know her history. And according to you and other people who've had conversations with her office, it doesn't sound like she knows. I'm going to give her the benefit of the doubt, but she needs to know about these situations. And we cannot pass a bill that is this dangerous, especially when it's not necessary. We have to always look, is this bill, regardless of what it's about, the environment, water, the air, school, is it even necessary? It's not necessary. We already have systems in place. Those systems we should be passing bills to make those systems better, not to take the currently existing tools and making them more obtuse, more broad, and then dangerously ambiguous so they can be misused by abusers.
Right. Well, here's another scenario. Recently California has designated our state as a sanctuary for what they call gender affirming care, which means top surgeries, transitioning drugs, including puberty blockers, cross-sex hormones, which have been very controversial in other states. We got over 20 states already banning these. You got Europe banning these drugs and surgeries on minors. And California has dug its heels in and say, hey, if you bring someone who's not the designated parent or guardian of a child in another state, you can bring them to California. California will take temporary jurisdiction over the child, but whoever brought that child here, how are they going to get treatment for them, right? Somebody, when they take them to the hospital or the doctor's office, they need parents to sign off on the drugs or the surgeries, and the parent's not around. They can use this form. They just fill it out in the hospital. The gender clinic takes their word for it. It says they don't have to check anything out. It would seem like this would be a perfect storm for anyone bringing a child from another state, wanting to get them their surgeries and drugs. I'm glad that many of these hospitals are now saying they're not going to do the surgeries anymore, but there's still plenty who do. Is that a possible scenario?
100%. So a couple of things. Number one, it's also a sanctuary state for for sexual reproductive health care. So AB 1066 or 1866, I'll get you the actual number. When that was passed, it said that anyone that brings a child here specifically for an abortion, but then the language was sexual reproductive health care. And then SB 107, Scott Wiener's bill that you were just referring to, making this a transgender sanctuary state. That means that California will Gavin Newsom has declared war on the U.S. Constitution. It's called the Full Faith and Credit Clause, which means that states are supposed to honor the laws and orders and subpoenas and warrants of the other states, right? Otherwise, we would just have lawlessness. And like you said, criminals would just go to the most convenient state and then they would run away to the next state after they committed their crime and then be like, oh, you can't touch me. No, we're supposed to be cooperating with each other when people violate our different states' laws. Well, California, Governor Newsom, Scott Wiener et al. Have said we are not going to honor the laws of other states or the court orders, like you mentioned. If I'm a mom and my ex-husband I have legal custody, meaning I have the child full time. I also have physical custody. I'm the one that makes decisions. He brings her, to California, and says I'm here to get her an abortion or gender affirming care. If I come here to the police department or to the court and say, here's my legal custody order from Tennessee saying that I have legal custody, I'm the only one that can get her this type of medical care, the courts will reject the case. The officers will not cooperate with the warrants or the extradition orders, and they'll disregard them. So you'll be at a loss. So that's why I mentioned at the top of the hour that people need to be sharing this with everyone in the country, because so goes California, so goes the rest of the country. If this passes here, it's going to pass in other states. And number two, no child in this country is safe if they can be brought here because of these laws that we're talking about.
Right. Well, we've gone a long time here. Appreciate. We've gone it over in depth. I think if a person listens to this, they should be ready to show up here at the Capitol on the 19th. There's going to be a 19th of August. There's going to be a rally at 1 o'clock. At 2 o'clock, there's going to be some lobby training, and at 2:30, we are going to go over to the Capitol to speak to our elected representatives opposing this bill. The bill is currently in the Senate Appropriations Committee. They have a hearing on the day before, the 19th. We expect this to be put.
Sorry. On the day before, on the 18th, on Monday, there's the Senate Appropriations hearing, and then the next day is the rally. So if people can make it, either one would be great, or both would be better.
Right. And then we expect the bill to be, put on something called the suspense file and then decided within the next week. But if legislators get enough pushback and they hear of the real concerns of multiple parents from all sides of society, this bill won't pass. But I realize you've just heard about this, and there hasn't been a whole concerted effort to oppose the bill until now. But folks, put this on the top of your list of something to speak to your legislators about, to your pastors, to other folks that you know. Sound the alarm. You can stop it, but only if people show up in mass and call in mass. We hope to have thousands of people up here. And so
and we can do that right now. We're very blessed to have had enough pushback to have this go through the summer session. So you can be making phone calls right now. They are on break. So if we were in a regular session right now, this bill would be being rammed through, and we would be having that typical whiplash of where do we go when, and them changing the hearings and all the things that they do. We have now 10 days to be making phone calls every morning on our way to work, every night on our way home, on the weekends when their offices are closed, leaving voicemails, registering our opposition, asking them to vote no on the bill, at the very least abstain on the bill, submitting our emails, asking for meetings, and we can even go visit them in their local offices, which is right a couple minutes from your home. Go to the coffee meet and greets, go to the ribbon cutting ceremonies, go talk to your senators now. And even, again, I want to emphasize, even the Republican ones, they need to be educating and spreading this information. And finally, also to Gavin Newsom. I do want to say this. If Gavin is really pretending he's going to run for president, then we need to be putting him on blast. Number one, this is a very dangerous bill. You got to step in. And number two, he claims to be an advocate for the victims and the survivors of child sex trafficking. Remember Shannon Grove's bills, SB 814 and SB 1414. He did intervene to help get those bills passed. So why not intervene to stop this bill that's going to facilitate, and in fact, encourage the exploitation of minors? This is within his wheelhouse, technically, if he's an honest person, which we don't know. But let's just call it what put him on call him, submit comments online, tweet to everybody, tweet your senators, tweet Gavin, ask them questions, let them know that you're paying attention, and you're watching how they're going to vote on this bill.
Thank you, Nicole, for your time, your advocacy, and all this information you've given us. So I appreciate your time, and thanks so much for being on our program today.
I love it. I love working with you guys. You guys, California Family Council, Greg and Sophia are the best. So we're so blessed to have you guys.